Hello, everyone. Thank you very much for attending this class. Our class today will be about contract law, and in particular, we will talk about exclusion clauses, because exclusion clauses is one of the most important topics that you should be aware of. It often comes up in courseworks and exams of contract law. We will go through the main principles that you need to know about exclusion clauses to be able to successfully answer a problem or essay question on this topic. And also we will go through relevant case law that you need to know. This is the clause which purports to exclude or limit the liability of one party for not performing his obligations in accordance with the contract terms. The definition of exclusion clause can be the following: clause in a contract or term in a notice which appears to exclude or restrict a liability or a legal duty which would otherwise arise. If you have a problem question about exclusion clauses, my recommendation would be to firstly define what is an exclusion clause, and then define what are the requirements of exclusion clause, and take it step by step. Apply to the definition the facts of the case that have been given to you. Does it satisfy the definition? Does the facts look like that there is an exclusion clause? If so, why? Make arguments, and then make arguments as to the requirements of the exclusion clause. Are they satisfied by it? And then conclude. If most likely on the facts given, the exclusion clause would or would not exist. The term exclusion clause is used to refer to both an exception clause and a limitation clause. You would encounter exclusion clause most frequently to exclude liability for breach of contract or negligence. However, if you see an exclusion clause that excludes liability for negligence, there are a lot of restrictions as to what extent a party can exclude liability for negligence, and you should be able to successfully apply the relevant law to see if in the particular case that has been presented to you, negligence liability could be excluded. The main problems that you will have when applying the law on exclusion clauses are the following. Is exclusion clause incorporated in the contract as a term? This is the first legal issue that you will have to address in the problem question about this topic. Cover the type of laws that has arisen. Not be rendered unenforceable by the statutory provisions in the Unfair Contract Terms Act and Consumer Rights Act. These statutes exclude a few circumstances in which exclusion clause may be incorporated. So make sure that the statutes like Unfair Contract Terms Act, Consumer Rights Act do not exclude the existence of this kind of clauses. There are various ways in which exclusion clause can be incorporated in the contract, and you need to discuss each of it and say which one applies to the facts of the case. It must be shown that the exclusion clause was validly incorporated into the contract. There are three ways in which a term may be incorporated, which are signature, notice, previous course of dealings. How do you decide which one applies? Well, you will need to have a look at relevant case law and find the case that most resembles the facts of the case has been presented to you, and therefore then apply it to the facts of the case. Notice must be given before or at the time of contracting. The case that you should know, Ollie versus Marlborough Court, this case is often cited when you're trying to establish existence of exclusion clause, incorporation of the exclusion clause in the contract by notice. A notice here in this case was about a hotel room which purported to exempt the hotel proprietors from any liability for articles lost or stolen from the hotel. And it was held not to be incorporated into a contract with the guest, because the notice was not seen by the guest until after the contract had been concluded at the reception desk. Therefore, the main principle that came out of the case of Ole is that the exclusion clause has to be presented to the party before the contract is concluded. Reasonable steps must be taken to bring the terms to the attention of the party. The case of Interferto is often cited for this principle. Here, it was held that a party who seeks to incorporate into a contract term which is particularly onerous or unusual must prove that the term has been fairly and reasonably drawn to the attention of the other party. Therefore, it is not enough to include the exclusion clause in the contract. The person may not have paid enough attention to the exclusion clause. Therefore, it is the responsibility of the other party to make sure that they take reasonable steps to draw this exclusion clause to the attention of the party who is signing the contract. Bingham J. Argued that case insufficiency of notice are concerned with the question whether it would, in all the circumstances, be fair to hold a party bound by any conditions of an unusual or stringent nature. A good example and an easy example to understand this principle would be if you go to any website to buy a subscription of the product. Most of the terms are obviously included in terms and conditions. They will not be able to show everything to you on the checkout page, but on the checkout page, they usually highlight the unusual terms that you need to be aware of. Incorporation by signature. The case of Lestrange, which is cited for parallel evidence rule. This is a well-established principle of contract law, which means basically that what is written in the contract will be enforced, even if the other party hasn't read it. There is another way of incorporating an exclusion clause in the contract, which is by previous course of dealing. A case that you can cite for this principle is British Crane Hire Corporation. Here, a clause was incorporated into the contract on the basis of two previous transactions and the customs of the trade. And the court placed emphasis on the fact that the parties were of equal bargaining power. What does it mean? Both parties were commercially aware of what were the customs of the industry, and there was no unfair power on either of the parties, and they were both in the trade, they were both aware of what are the rules in the industry, and therefore the exclusion clause was habitually incorporated into this kind of contract, and they were aware of it. For the purposes of the exclusion clause, you should be aware of unfair contract terms. This is a very important act that you will need to take into consideration. There is a little need for such a restrictive approach, even in the case of exclusion clauses. So Unfair Contract Terms Act contains a reasonableness test under Section 11 that gives the courts a power to exclude a clause if they consider under Section 11 that it was unfair. Interpretation of exemption limitation clauses seeking to exclude liability for the party's negligence. So what happens when a party is seeking to exclude liability for negligence? The courts are unwilling to give effect to exclusion clauses which exclude liability for negligence. The case that you can cite is Canada's Steamship Lines versus the King. The following test was established, which the courts will consider when assessing whether an exclusion clause excluding liability for negligence will be valid. Whether the clause, where the clause contains language which expressly excludes liability for negligence. Therefore, this case allows the possibility of liability to be excluded for negligence. Where the clause does not expressly exclude liability for negligence, but excludes damages, which would be considered to be negligent damage, what happens then? If the clause language explicitly refers to exemption from liability of the consequences of negligence, the courts will uphold the type of exclusion clause. A strict interpretation of this case was established in the case of Monarch Airlines. If the wording of the clause must be construed to cover negligent liability, negligence must be clearly have been in the contemplation of the parties when this was being drafted. The words attempted to exclude liability must also be clear and unambiguous. Therefore, it is possible to exclude liability for negligence, but there are very strict rules about it. Statutory controls on exclusion clauses and unfair terms. There are two acts you need to know: Consumer Rights Act and Unfair Contract Terms Act. There is a difference between which one applies in which kind of circumstances. If it's a business-to-business transaction, then it's Unfair Contract Terms Act. If it's B2C transaction, business-to-consumer transaction, then it's Consumer Rights Act. Terms subject to reasonableness test. Unfair Contract Terms Act. Section 2, clauses which purport to exempt limit liability for negligence. These are subject to reasonableness test. Section 3, clauses which purport to exempt liability for breach of contract. Within scope of actor, be subjected to the reasonableness test. Outside the scope of the act, no general doctrine of unfairness or unreasonableness to which the party seeking to set aside the term can appeal. The reasonableness test is under Section 11 and Schedule 2, guidelines for reasonableness, relative bargaining power and degree of notice of the term. Therefore, when it comes to exclusion clauses for negligence and breach of contract, it will not be automatically accepted. It has to go through Section 11 reasonableness test, and there is guidance as to what is reasonable and what is not reasonable. There is no such thing as general reasonableness requirement or general requirement for fairness of the contractual term, because the courts do not want to interfere that much in the business world. However, there are guidelines, and the guidelines take into consideration the bargaining power that there was on the facts of the case for each party, and degree of notice of the term, which means that the party that was entering the contract draw attention of the other party signing the contract to this exclusion clause that was excluding liability for negligence or for breach of contract. I would like to now present to you the information about how we can help, about simple studying, and how our platform can help you. We have content creators who provide content that is a simple study materials for students to help you get the highest grades in the simplest way possible. We have simple notes, simple model answers to problem and essay questions. We have a model answer for misrepresentation and exclusion clauses as well, which often comes mixed in a problem question. We have tutorial videos like this one that explains in simpler terms complicated legal principles. We have quizzes and flashcards for further practice, and interactive learning platform where you can connect and study with the rest of the community. If our resources are not enough, we have additional service that we offer. It's called Tutoring Services, which is basically a one-to-one meeting with our tutors, myself or my colleagues, and you will be able to discuss any issue that you may be experiencing in your legal studies and get personalized support. We have already helped thousands of law students to get high grades. 90% of our regular users get a first class. The regular users are the ones who regularly study with our simple study materials and also get few tutoring sessions to maximize their chances of getting high grades. We would love you to be our next student to get high grades. Please join Simple Studying now.